I haven't had a chance to update the sort of the task list. Because I'm hoping, Aaron, you can kind of go through some of the stuff that you and Alicia have started to work through. One second.
Sure. Yeah, I think we can go through the memo that we sent last week to start,
Yep,
because that was
yep,
kind of our first marching orders, and we got some research done for that that might be
great,
useful.
perfect.
Um,
See what I've got here. One second. I just want to see if I can. Um, when was our last meeting? Was it the 23rd of January? Yeah, I guess that's right. Okay. So you had sent, let me see something here. Tate's not on yet, right?
He couldn't make this meeting. He's on his way back from Florida.
Oh, he is. Okay.
Yeah, I don't think he can make this one or the 21st, unfortunately.
Then I'm gonna have to see if we can get somebody else from the ZBA, because the first thing was the ZBA application form and that checklist. I wanted him to get with Susan Meany on it, because Susan created a checklist for the planning board that's really helpful. So we just want to get that updated for the website, and then the seeker forms is the same. So I'm going to ask Frank Rettel if he can help out with that. Special permit review. Aaron. Oh no, that's actually something I was hoping Tate could get with Susan Meany on. I'm going to reassign these to Susan and Frank Rettel and see if they can help. It's a checklist for residents on
yep.
what requires a special permit and what doesn't. So let me just make a note of that. Hold on one second.
If you need us to step in and help on that, we can. It's really just a matter of looking at the chart of, the permitted uses chart at the end of the zoning code, which has what's permitted by site plan, what's permitted by special permit, and just trying to get it maybe all in one place, early on in the code, I think, or somewhere. I think the only ZBA special permit that we're familiar with, because we've seen it a bunch of times, is the one that is needed for expanding a home or a non-conforming structure by 25%.
Okay.
That might be the only one. The planning board has more, special permit uses that they have to look at, which are all in the tables at the end of the code.
Okay. Okay. Yeah, I'm hoping I can have them do that.
Yeah, let us know.
Yeah, but if not, just because I don't think it's just a matter of doing some, kind of work on it, right? It's not they'd be able to figure it out, right? It's not like something we need sort of expert input on.
No, it's all.
I think it's good for members of the committees, to get their arms around that too, probably.
Yeah, true. Yes, for sure. So I'm going to ask about that. Oh, I also should mention to everyone that Margaret is the new representative for the CAC on the task force. Pam just had a lot of different town assignments, and so Margaret was kind enough to step in. Okay, so APA overlay applicability. Is that one of the things, Aaron, that I know you and Alicia have sent me a ton of emails, and I'm so sorry. I just got back very late last night from my children had a long weekend, and I've just been.
I think that's it's more of just a typo correction, right?
Right.
There's some
Okay.
inconsistencies between Appendix A and the text.
Was that
Section
one of the ones that
315.
I was sending to Megan as keeper
I
of
think so.
this?
Yeah.
Okay.
And she couldn't make it to this one, right?
No.
Okay.
And
So maybe,
I just wanted to keep this meeting, even though I know we were all kind of, because I just wanted to, even if we're on for another 20 minutes, just to keep the momentum going of having check-ins. And I'm actually having a call with our former clerk, Mary Alex, later, because there's a couple things I need to check in with her about. And she asked me how this was going because we have contracted with this company. I want to call it eCode, but I don't think that's correct. But that will put all of our code and all of our maps onto the web. I think, Aaron, this is what Dover uses and a bunch of other municipalities. We
Yeah.
have the contract with them. We just didn't give them the things to upload because we were going to make these changes. And so she was just checking. I was checking in with her about the contract, and then she asked about how things were going. And so anyway, she was a couple things she wanted to make sure that we covered. So I'll just check in with her too about that stuff. Site plan and other requirements for special permits waiver, Emily, and recommendations from
It's supposed to be off AKRF.
I know. I said, what did I write? AFRH. Okay, AKRF.
It's not the first time. It's okay.
Sorry.
So our memo that we sent around last week had some stuff about this. It's really, bottom line is the code already has pretty clear language in there that the boards can promulgate, lists or rules or requirements for certain types of special permits that might not need a site plan. So I think, we could we gave one example in the memo, which was, a reuse of a commercial building, the interior space, and there's no changes to the outside. It's just kind of a change in use that requires a special permit. And for that reason, the planning board might not need to see a site plan because there's nothing changing on the site besides who's the tenant of the building. And that was something that came up last night in the application that the planning board just granted for special use permit 3788 Route 44. That's an example of one where they waived the requirement for a site plan and all the things that go along with the site plan because per the applicant's application and information they presented to us, they didn't plan on changing anything outside the building. There was enough parking. There's no, the lighting wasn't changing. Nothing happened to the building itself outside. So that was an example. So it's up to the, if the boards want to start thinking about what do we see a lot of that this comes up on and, coming up with like a list or a policy that I don't think it needs to be codified, right, Alicia? We kind of talked about like it might just need to be something that they do as a practice, right?
Yeah. Our general recommendation is that the board could have a list that they promulgate that's internal. I mean, that's like an internally decided upon list that's available to the public, but it's like part of the board's procedures. So it doesn't have to be, codified into the zoning code. It's just an internal operating procedures list. And then on top of that, the board would also maintain their authority to waive site plan or site plan requirements on a case-by-case basis. And that does seem to be what the code is saying right now. But just that's what the code is saying. It's just not saying it very clearly. So that was our recommendation. And like Aaron was saying, there could be a sort of a broad rule that if a given application would not affect the characteristics of a site or increase various requirements under the code, then it would be eligible for waivers.
Okay, what does the rest of the committee think about that?
You mean codify versus not codifying it?
Yeah, what are your thoughts about, to me, having it be as clear as possible makes sense. Or does it limit flexibility? I don't.
So, just so I understand, are we talking about basically including something in the code to the extent it's not already clear that says we have the ability to promulgate a list, create a list that's be voted on or approved by whatever committee needs to, what if it's the planning board or the zoning board of appeals, but not codify that list so that if it needs to be amended or adjusted over time, we don't have to go through the process of reenacting new legislation unnecessarily. Is that the idea?
Yeah, and this wouldn't require a code revision necessarily because it's what the code already says. If we were starting from scratch and rewriting it, we might write it more clearly, but I don't think that this needs to be revised because what it says is that the board can decide that certain types of special permits don't need a site plan. And then elsewhere it says, so it says, yeah, the board can promulgate rules and regulations as to which specific requirements may be admitted for certain types. And then, yeah, elsewhere so it seems like it's already saying that you can have a list and it can be case by case.
So is the idea just to provide the list on the website for the use for residents?
Right. Yeah.
Perhaps. And the boards would have to come up with that.
And you would qualify it saying that these things are potentially eligible for waiver, so that it's not that people think, oh, if I meet these requirements, then I definitely don't have to do a site plan. But that's just
I see.
Say that, hey, these we will consider.
It could help folks going into the building department where they present what they want to do to Jonathan, and he says, "Oh, well, that would be a special use permit, and a site plan should be done." If there's a list that he's able to see also that, and whatever is being proposed maybe falls into that, he can tell them, "Oh, well, you might not need a site plan, so just give them as much information as you can on the application, and note that you think that this can be waived for site plan based on this list that exists." I mean, that could be another helpful thing that gets done at like the gatekeeper level, right? When someone comes in, because what happened with that 3788 application was they prepared like this whole site plan. They like showed like formal parking with like striping in the lot and stuff, and they're like, "Oh, we're actually not planning to do that. We want to keep the parking lot like it is, just a gravel lot that has plenty of room." But so we were confused, like, are you formalizing it or are you not? Because you're adding impervious. What are you doing? And they're like, "No, we're not. What the building department told us to do a site plan, so this is what it is." So we're like, "Well, you didn't need to." So if that can be, kind of caught early on, then we could avoid, us spending a lot of time and money writing comments about something that might not be applicable, and it'll save the applicants a little money on their end for what they have to have prepared.
So would it be your recommendation, Alicia and Aaron, that we kind of bring this to the planning board and ask them to come up with a list of things that they think would be exempt from requiring a site plan?
Yeah, but it should also be with the ZBA because at least some special permits, at least all the special permits we've seen, go through the ZBA.
Well, the special permit for the expanding 25% has a site plan requirement associated with it.
Yeah.
Which makes sense because you're building onto a house and like you need to see where the addition is and how it relates to everything else on the site. So I don't think we're going to change that requirement. We're not talking about that. But I think, and again, that might be the only one that that the ZBA that ties into site plan that the ZBA looks at.
Okay. So then,
So maybe it's more of a planning board job to try to think of, and there's enough institutional memory there, I hope, too, to come up to think about projects that might, and examples of types of projects that might not need a full-blown site plan.
Yeah, and feel free to use in the memo, what page is that? Page 7, the first paragraph under waiver of site plan requirements for certain types of special permits. The language that's in that paragraph is from a different municipalities code where they're talking about where a site plan may or may not be required. And I'm bringing that up because that language might be helpful in thinking about what types of applications might fit within those terms. So the language here is that would not affect the characteristics of the site or increase the requirements under the code in terms of parking, loading, circulation, drainage, utilities, landscaping, or outdoor lighting. So you can think of that as like a framework of what type of applications might meet that criteria. might be helpful in working out a list.
Okay.
I mean, okay.
You look distressed.
Oh, sorry.
No, I'm not just, I'm just thinking. I'm not distressed. I'm just thinking. I guess we started out thinking that we wanted to have a clear list and actually put that in the code. And now we're thinking we might not need to put it back in the code. But I guess, I mean, if we're just talking about a list for internal purposes, essentially, I guess I don't know how helpful it is to have this informal list floating around. I'm not sure that resolves. I guess my question is whether that actually creates more questions than it resolves. And I mean, I guess I'd have to give it more thought. Maybe other members of the planning board can think of an easy way to describe the kinds of scenarios where we might waive site plans other than what's already described in the code. But I guess as I sit here today, also a little tired, I'm not 100% sure I can think of a way to describe that. That's going to be, I don't know. I can't think of examples.
And it might evolve, right? As you get, because, you know, different things come in over time, and something we didn't think about could be presented and say, oh, well, this happens again. Maybe we want to just be aware that we didn't ask for a site plan and we should do that moving forward. Yeah, I think it's just more of like a procedural, like, you know, understanding from everybody that you have the ability to do this. Maybe they don't want to come up with an actual list, but that they just keep it in the back of their mind that, you know, if it's not something that's going to change at all the material conditions or environmental conditions of the site in any way, and it's not going to generate a large amount of traffic over what might already be happening, things like that. Doesn't need new access points or anything, like, then you don't need a site plan. There's no wetlands or, you know, that kind of stuff.
You know, Aaron, as you're saying, what might be useful is for us to just think about instances in which we've done that and actually cite like specific examples, right? So like the one that we approved last night, maybe the Orvis. I think didn't we waive site plan approval for that?
No, that didn't get waived because that was that actually was a site plan.
Okay.
I'm sorry, wait, I'm thinking of like Orvis. Since they were building an addition onto the building, it made sense to see the site plan. So we definitely treated that like
that one.
Yeah, that was a site plan review. We had to make sure they were beyond 100 feet of the stream, and we asked for a lot of stuff. But we didn't ask them to, like, you know, show us that you're going to pave your parking lot and put, you know, show us where your parking lot is now, that it has adequate number or adequate capacity for your operations. But they didn't propose any changes to it. They just, we wanted to see it. So a site plan was appropriate for that.
Okay.
Okay, so where do we fall out on that? You feel like, Emily, we don't need the examples?
I mean, I think it would be good to get Susan's view. She's been on the planning board a lot longer than I have, and I think she'll have a clearer idea of examples where they waived it, where it would have been useful to have been able to waive it earlier on.
Right. Right. You know what I'm thinking as I'm looking at this is, you know, the next planning board, like making a list of these things. The next planning board meeting is March. You know, it's a while. I don't know if you guys ever have anything. I think it's the 5th of March.
Yes.
You know, if maybe we see if we can set aside some time at that meeting to go through some of these things that, you know, make sense to get broader planning board feedback on, or I can actually just send it to the to Susan or to, to the committee or, Emily and Susan and say, what are your thoughts?
That
We
might
don't
be,
want to wait that long.
that might be a good idea, or at least to get everybody thinking.
Yeah. Yeah, I can easily put that on an email with all the planning board and just say, okay, here's some stuff we're looking at. Can you give me your thoughts on these 5 things? And then ask, someone on the ZBA to kind of work on some of those earlier things, those forms and application forms. On non-conforming structures and uses, the expansion of non-conforming uses, this is the 25, this is the one that's like
Yeah.
the here. And Aaron, I think you and Alicia
didn't-
did work
We
on
didn't
that.
cover this one yet. Yeah, well, I think we had your instructions was kind of like this will be tabled. We have to deal with this a little bit further, and Megan was going to get involved. So
Okay.
we didn't focus on it for this meeting.
Okay.
Yeah.
All right. I will flag that then. And then the same thing goes with number 7, which is unclear whether section 319 is meant to apply only to non-conforming uses, buildings, and structures, or if it should also apply to non-conformities. The text of the section uses these terms interchangeably, but they have different definitions. So I guess I think, and tell me if I'm wrong, that we need to sort of sort out the earlier question about the nonconformity. And oh, I know what we were doing here. Okay, sorry. I'm getting.
Pam and I looked at this.
Yes. This is one of yours, and this is you and Pam here. But
I think it wasn't really. I think there really wasn't an issue when we looked at it.
The legal memo from Vanderwater Section 39 does not apply to this. I think that this is the one where there was the CAC had an opinion. Sarah Wilson had a different opinion.
Yeah.
And so we're trying to figure out because I think where the confusion came is, what is the nonconformity? Is it the structure or the lot and the setbacks? I think, right? Am I remembering this correctly? Maybe I'm wrong, but that's what I remember the issue being. And then Sarah had a different recollection. And then there was a question about looking back to see what the original intent of the code was when it was drafted.
I think Pam did that.
And Pam looked into it but couldn't find anything. But then Vanderwater did find something. And
Or did we might have
circulate that, or you guys did.
Did we find I think we found the local law, right, Alicia? I remember sending it around and saying, look, like this appears to be when 391.7 was updated, but there was no context at all as to what the thinking was. It just had what was done, which is what we see now.
Right. Well, the intent matters, right? Unless we want to send the whole thing back to the town board for discussion about why, about the intent of the law to begin with.
Yeah, we tried to track that down. We couldn't find anything.
I can interject. I remember when that happened roughly, and it was several years after the law was written. People were complaining there was no leeway whatsoever to do anything under that section, so they added that 0.7 part to it. And that's the context I remember, at least. Not official, but that's how I remember it.
And the 0.7 is where
91.7 was added later because people were complaining to the planning board at the town board at the time that there was nothing they could do with that property, no loopholes whatsoever, and that was added to give people a little bit of leeway.
Right. Okay.
25% expansion.
Yes. Yeah. If it was before 1971, that's the other part. 1971 was a previous plan, comprehensive plan. So if you were under the previous comprehensive plan, the 1971 version, you could do something with expanding that property, and only 25%. And that's where the 1971 number came from. Then there was a 1972 plan, which was not included in that. So you had to be way back to 1971. But the reason I remember, this is unofficial, is that people were complaining because there was no leeway whatsoever in that section, and that was added several years later.
So the intent of this is to allow people to expand their homes that are currently non-conforming, but not so much so that, right, that it becomes, that it's,
Well, the intent at the time was that if it was in existence from 1971 earlier, which is earlier master plans, you could have a little bit of room there. You could have a 25%, up to a 25% expansion allowed under that section. Before that, you couldn't do anything. It just said this, and this, and you can't do anything with it if it's this, and this. So that was to give people who complained to the town, I'm managing town board at the time, a little bit of extra room to do that. And it came around in 2005, I think, something like that.
Yeah.
Way back.
So 25% was the agreed upon number for whatever reason, and anything that goes beyond that, because we have seen applications that go beyond that and they get a variance from the ZBA to go beyond that.
No, that was the variance. That 25% wasn't a starting point, it was the ending point. You could get up to 25%. That's what they allowed people to have to sort of mitigate the section slightly, to ameliorate it slightly for people who wanted to expand beyond what was not allowed. And it was only if the property was old enough, that went back to 1971 and earlier, that you could expand that piece of property. It wasn't a starting point, it was an ending point.
So you're saying that if a home or something was built, say like in the 80s, and it's non-conforming, that it wouldn't be eligible for expansion at all?
Yes, that's what I'm saying. That was exactly the intent. And the reason the 1971 number came up, because that was the end of the previous comprehensive plan. The next comprehensive plan started in 1972. So if anything was done under that comprehensive plan, you couldn't change it if it fit the rest of the definition of that section. That's where the 1971 number came from. It was, if you were that far back, we'll let you do up to 25%. 25% was not the starting point, it was the ending point. I don't know if I'm explaining that clearly enough, but that's what the intent was.
Well, the ZBA grants a little bit more than 25% as a variance, and they've been doing that according to John Precy.
I know they've been doing that, but the instructions were, if you go to the ZBA, ZBA can only do up to 25%. That's what it says in the code.
Through a special permit. And then if they want to go beyond it, it's technically a variance.
They have to get a variance. Yeah.
That is the variance. They're giving a variance. I can't pull up my might as well just say the ZBA can grant any variance they want. That is the instructions to how much variance they can give in the code. Up to 25%.
I don't know.
They go beyond it, but I don't think that's proper.
Can I just
personally,
Howard, I'm sorry to interrupt you. Can I just jump in for a minute? Because I'm remembering, and I can't pull up that unfortunately that Excel spreadsheet, Leslie, with for some reason I can't pull it up on my work computer. But I'm just remembering now when Pam and I had looked at this, I think the question before us was this inconsistency between the language, right? Am I remembering this correctly?
Yep.
Right.
Yeah.
And then when we looked at the definitions, they were really used interchangeably. So the definitions, I think, and I can focus back on this with it, Margaret, if it's you and I now, we can look at this. But I think, if you look at the definitions, they're really, it's not clear where one begins and one ends. And if they're used interchangeably, then I think it's just a matter of cleaning up the language to resolve the confusion, because the definitions are not... Non-conforming uses, buildings, and lots refers to non-conformities. Non-conformities includes non-conforming uses. And so I think if we're worried about inconsistencies between definitions, I think maybe I'm oversimplifying, but I think it's just...
I think what Howard just I think there's two things. I think it's that, right? It's understanding, because wasn't that the concern of the CAC was that the planning board couldn't have granted that because it wasn't allowed because of the 25%. And but I think it's because of the confusion or the lack of clarity with the definition itself. So that's one issue. And then the second issue, or it's not an issue. I mean, I do believe that and this might be a question for Vanderwater, but that the 25% is what's in the code that you're allowed for a special permit from the planning board, but you can go to the ZBA for a variance if you establish
Actually, it's
criteria are, no, to have.
well, you can go up to 25% through a special permit from the ZBA, and then you also need to go to the planning board for a site plan if you get that. But the ZBA has been treating, if there's expansions that go slightly over that, 25, 30%, 32%, they've been granting that with a variance. And Kyle's been aware of that from Vanderwater, and it's not something that's been really brought up as
relatively
kind of
recent.
Yeah.
Relatively recent. They never used to do that. It started recently. And you're correct, they've been granting more than 25%. And so the question is, why doesn't it just say the ZBA can grant whatever size variance they want then? This was an instruction written into the code for the ZBA. This is what you, ZBA, can do. And, if you want to change that, that's fine. But this is what it says in the code. You, the ZBA, we, the town board, wrote this section of code, and we're telling you, the ZBA, this is what you can do. And the number is ending number is 25%. If you want to change that and say you, the ZBA, can grant whatever size you want as a variance, that's allowable, but that's not what the code says. That's not what they're instructed to do by the town board.
Okay. I don't have the answer because I don't have the context. I don't,
So the context of this would be determined in minutes from the year 2005 when they changed this and
If that's the correct date.
If it's the correct date, but when they added the May 13th, 1971 into that, it would be in that year in minutes. Somebody could be looking through the minutes to see what the verbiage is on.
If you can find it, yeah, if you could find it.
If those minutes exist somewhere. But it should be, when I went back and looked through minutes for code information from 1989, I found, loads and loads of information of what people's determination of what they wanted in the code was. And it was all there. It's all written in the minutes.
Yeah. All I know is this came later. This was not part of the original code that they wrote. They added that section 91.7 later.
It's in 05.
Okay.
So Margaret, do you know where that, if you're able to find that, or you can help track that down for you and Emily, that would be really helpful, because
that's going to be the easiest way.
I just want to get it sorted out. Yeah.
Yeah. It'd be the easiest way to determine what the intention is.
And then if that's something that doesn't make sense in 2024, I don't know if it would, that's something that, that I can circle back with the town board on, but I think it's helpful just to know what we're looking at.
Well, I think in part, if you look at the vision statement, you'll get a sense of what they were doing back then too. And the intent, as I remember, was to protect farmland and to keep the town rural and the village the one center of commerce. I believe that's, what the vision statement would say.
My understanding is from somebody, and I don't know who said this when I emailed about it. I checked in with, maybe it was Pam sent it or someone, that they were trying to stop McMansions being built in the 80s, was sort of the thinking behind this and limiting that growth. Okay. Okay. So that's seems to warrant.
So for that one, Margaret, should you want to just?
Since you are very good at tracking stuff, are you able to connect with Emily on that and figure out what the minute said and what what we should do on that one?
Yep, I'll research it. I'll get back to you, Emily, on it. And get
Okay.
you the information. And we'll discuss.
Sounds good.
And then on the comp plan, we talk about buildable land on steep slopes. We can change that from, I'm going to make a proposal to, just to change it from the 20% to 15%, because that was recommended in the comprehensive plan. And then on the educational facilities and definition of what an adult seat is, AKR,
Yeah.
if you were going to get back to us on that.
We looked into this. It's in the memo that you got last week.
Okay.
So, Alicia, you want to summarize? I mean, it's really a matter of like the adult student seat thing is just not maybe not be the way to go, and we should just go with what some other municipalities have used. And I think this is really focused on private schools, right? Because like
Right.
when a public school is built, it's not something that goes through the town planning board or zoning board of appeals usually. It's
Right.
private schools are what this is coming up on. It came up on the Upton Lake school. And you only have a couple of, right, you have a few private schools in town that might be looking to grow and when this would come up. So we had some recommendations for making it just go by like enrollment or capacity, right, Alicia? I don't have
Yeah.
it in front of me, but
Yeah. So yeah, like Aaron was saying, most codes don't address public schools anyway. But based on what the what's the transportation,
yeah.
what's the I stand for? I forget. It's
Institute
not-
Institute of
Institute.
Transportation Engineers. Yeah.
So based on that report and looking at some other municipalities, our recommendation is to base the parking on student capacity. Some of them talk about enrollment, but that's really hard because you don't know what enrollment's going to be. But capacity, ultimately our recommendation would be 1 space per 3 students in high school, 1 space per 5 students for elementary and middle. And the reason why you would still have that many for elementary and middle, because at first I was like, that's kind of high. Like, why do you need 1 space for 5 students? It's just because you have so much administration. So
And we ran this through our traffic folks that do a
Right.
lot of this, and they know the ITE manual pretty well, and there's really no clear requirement in that. But based on, projects that we've worked on, and just the institutional knowledge of folks that familiar with some of these, and we looked at neighboring municipalities, it seems
Mhm.
like the 1 per 3 high school, and the 1 per 5 would make sense, in addition to what's already required for faculty, which is pretty clear in your code already, right? It's 1 for every employee.
Right. Okay.
But right now it says 1 per employee plus 1 for every 4 adult students. In this case, we're kind of making it keep that 1 per employee, but then make it 1 per 3 high school and 1 per 5
but that
elementary,
I think
middle.
wouldn't that be kind of excessive if we're having
If there's already 1 per employee,
because then like for say elementary and middle, if we have 1 space per 5 students, obviously none of those students are driving to school.
right? So maybe
So
we're focusing on high schools.
Okay. And that's 1 per 3 students.
Are we thinking of like drop off when we're
Yeah,
maybe, because
that could be what the 1 for 5 elementary and middle is if
Yeah,
a
I
parent
mean, I
is
think-
needing to be on site for some reason.
we'll drop off and pick up, right? So
Unless there's a drop off and pick up line, like the
Right.
temporary.
I think some schools have that and some schools don't.
Yeah. So
And
maybe
I
that's
think-
why we
But that would
maybe-
be like a drop off area as opposed to having like designated parking spots. Unless they require the parents to park and walk their kids in. Yes.
Yeah, well, I
it's
think
going to be a
that's-
case by case thing. And I think doesn't the
Right.
planning board have ability to waive based on situations like, depending on, I don't think you're going to see any applications for a new private school anytime soon, but what we're seeing is if Upton Lake, for example, they wanted to build that new building to improve their high school situation, because right now they're in like a house and didn't have a lot of space, and they want to increase their enrollment. So that was, they redid their whole parking lot to show that they have plenty of parking. So I, you know, if there's still the ability to have discretion about this, that's good. But I think we should have a number that is clear, you know, and not questionable. Like, what does an adult student seat mean? So.
Okay.
And that makes sense to have the default, but keep it flexible because you might have a school that says, you know, we don't allow students to drive to school, even if they, you know, can drive to, like, even if they have a license, they're not allowed to drive. So they have a rule like that, then, you know, their parking would make sense if it was less. But,
Yeah, and you don't want to make them add more parking and more impervious if they don't allow their students to drive.
right. So you have a default, but then you have flexibility.
Okay. All right, that sounds good. That sounds good. The NRI, they have the photos from me, they're inputting the maps. Margaret, they sent anything to us recently? Christine sent me that email last week that they were putting in the maps. They thought they could
Yeah,
get.
just
by
that she would get that to you by tomorrow or sooner. So it's apparently tomorrow.
That's not going to be, that's not enough time for I mean, we don't need to have a public hearing, by the way, to adopt the NRIs.
Right.
But you know, the public wants to look at it or whatever. So I think I'm going to set a date. Actually, that's what I need to do for a special board meeting to do that.
Can I ask a question about the NRI and just
Yes.
what we're doing? So once these are adopted, and these include things like I know there was like so there'll be like a map of like steep slope areas, a map like the updated wetlands map I think is part of this, and then there'll be maybe some like possible wildlife habitat areas of concern. These are all that's great because right now we don't have any comprehensive set to go and check against every application we get. So the idea here is that there's going to be this set of maps that now AKRF can go, and when a proposal comes in, we can flag it for anything that, you know, that
100%.
is identified. Okay.
Yep, 100%.
Because right now we're seeing like we have some comments from the public on a certain application that's citing maps like that look like this that we just haven't seen before. So if the intent is for those to be now,
That's,
you know,
that's
official
people-
town maps and
Yeah.
something that we have to check each application against, that's great.
Yeah. So what the DEC did with Cornell is they took the Hudsonia habitat study
Yep.
along with all of the recent mapping that was done from the CPRC and the recent mapping from county and brought it all together. So, Margaret, did I explain that correctly?
Yes, you did.
Okay. So Margaret's in my view, the map guru.
Okay.
So, and I asked the DEC, how do towns go about adopting this to become their formal reference map? And there's a bunch of different ways to do it. But resolution is one of the ways. And so I sent it to Nan Stolzenberg and Jim Stout, and they've drafted, a resolution for it. And so we can, as soon as we get it, we can go about adopting it. So
Okay, good.
I told the town board I have to take up my daughter to California tomorrow for a college related thing for a meeting with a professor. And so I will not be at the meeting because I'll be on a plane, but so we're going to set a date so we can get that adopted. And I also just didn't want to adopt it without having it at least posted for some time so that residents can look at it and ask questions if they want to. And then the land conservation zoning district superseded. Megan was going to make that change to the code. And then planning board's option to require a cluster plan on a subdivision.
Yeah.
That's a question that I know that Susan's working through on an application that,
I think it's clear, like we're, and the board is aware of what, through Megan, and is aware of what we can start to apply when it comes to this. So I don't think there's any reason to change it, but the only unclear part about it, and Emily, you can weigh in, but it's kind of like the way it's written implies that there's development proposed at the time of coming to the town, whereas we
Right.
have seen situations where there isn't that, but we might still want to do this. And
Right.
it sounds like the board's going to move in that direction.
Yeah. Yeah, I just,
Um,
it's unclear to me, like, I guess I don't understand it well enough to have an opinion about it, meaning that, my thinking about, in my mind, what it means, my understanding, I should say, of cluster planning is that it's often done for developments, right? Where you want to
Yes.
have all of the houses in a particular area so that you get to preserve more open space. It didn't
Yeah,
seem
that's
like
exactly it. Yep.
that really should, if people are buying a 10-acre lot, we shouldn't be or in the case of the Johnson property, 100 acres, 20 acres, 30 acres, we shouldn't say to people that are buying property that are within our code that are abiding by our other laws, wetlands and otherwise, that they have to have their house in this corner of that that parcel so that
Yep.
it's closer to the other. That's
Well,
the
it's
whole
the
why
way it's
someone
set up and the way the code is worded and the way it's more of it's a process that the planning board has to go through. It's a decision-making process based on getting information from the applicant about what's on the site. There's a land inventory requirement. It's in the code. So I think it's based on getting the information and then working through,
the
what's out
questions
there
and
and do we really
criteria.
need to require this or not? And they make the decision.
Right.
That's
Yeah,
kind of
and
how it
I
ends up.
think
But how is that different than what it says?
there's,
It's
in some
suggested
instances,
plan.
A
I
lot of
don't
discretion in it.
But how is that different from what, aside from the question on a recent application on this issue, does the code need to be changed? Like, it's one thing if maybe we want to go through a more formal process or a checklist to make sure that we're considering that, right? Or the planning board is considering that before it approves an application. I guess what I'm getting at is I don't know that subdivision regulation well enough to
The
know.
only, yeah, I
Yeah,
get what you're
whether it's
saying.
covered right now. You know what I'm saying? Whether the code
Yeah.
itself is comprehensive
I
enough.
think it's pretty clear when it's required, when you require that process. But then after that, there's a huge amount of discretion. But I think at the moment, the threshold questions are pretty clear about when you need to go through that process.
Yeah.
But
The most helpful thing would be maybe, and it's just a thought, that it could just say like whether or not a development is proposed at the time of application. If it's if it doesn't meet the minor subdivision definition and it's, over 5 lots and all that this should be considered. Even if there's like not a plan for building anything at the time of they come in.
I
What
don't
do
know.
you
I
think?
feel like we need to think about this a little bit.
Okay.
Like I don't know, because there's some, for me, cognitive dissonance between cluster zoning supposedly being beneficial for the environment, and the comprehensive plan, right? So there are, and I'm going to muddle through this. There are there might be a proposed subdivision that could fall into the category of cluster subdivision, but the cluster subdivision is at odds with our comprehensive plan, that wants us to keep the rural character of our, community, and it might actually further disrupt greenways, right? It's not necessarily better. And so I think
that was my question. That was my thinking. I think on the last call, I said, I just don't understand. I don't understand the sentiment behind it when, I understand it if you're in a 1 acre zone or a 2 acre zone, where it's like houses are super close together. If you're planning a development like a Silo Ridge, right? If you were planning that, I don't know where in our town, currently that could take place. Anyway, I guess if someone lives on a 5-acre lot, they should be able to put their house where they want it, as long as it's not near wetlands and it's not a steep slope and all that stuff, as long as it's meeting all the other criteria. So I just don't, anyway, I don't think that's why people move to a rural area, to be clustered next to seeing their neighbors. I guess that's what I'm.
Yeah, I think that's the dissonance. It's there's definitely some tension, and I think when you look at some of the cluster subdivision regulations for other areas, it makes more sense when the objective is to preserve some green space when you're making these small developments with smaller lots, and those green spaces often like for the community to use collectively,
or a conservation easement with a local land trust or something.
Yeah, I mean, listen, I grew up in New Jersey, so I totally understand what, in my vision, in my view, that's what, that's kind of areas like that, or Long Island, or where they're doing that because there is no green space, right? They're trying to optimize the green space around it, so it's affecting the neighbors less. If there's a huge edge, you'd probably want all the houses in the middle so that there's green around it, so that it's not, there's more of a continuous green space around for animals and all that, and neighbors. But anyway, so I think this warrants more of a discussion, maybe an in-person discussion, kind of working through it. And I need to look at what is actually in the comp plan on it. Obviously, that's a suggestion. And I just want to understand, is it a suggestion for the village? Is it a suggestion for the areas of our town that are 1 acre, 2 acre, not 5 or 10 acre, where, I think it defeats the reason why people want to buy a 10-acre property and keep their, they should be able to put their house, in my view, where they want to, as long as it abides by the rest of our laws. Okay, so that's more discussion, clearly. Same thing with the next one.
Yeah, it's related to it. Mm-hmm.
This one, sorry, farming.
Could you email me the Excel, or somebody who has the email readily?
Not updated, so but I will send you what I have. Hold on a second.
Okay, thanks. Sorry, I don't know why I can't seem to.
The farming thing, I think Aaron and Alicia, you guys might have done some stuff on that too, or maybe not yet. I felt like
the farm worker housing.
Yeah, we have some info on that.
Yep. Right. So basically, we compared town of Washington requirements to Amelia and Pleasant Valley, and also to the guidance from the State Department of Agriculture. And sorry. The main thing from the AML is that the municipalities process for anything related to agriculture, including farm worker housing, can't be unreasonably restrictive. Sorry, and so the state has suggested guidelines for how to review these sorts of applications that are not going to be too restrictive. Ultimately, what we recommend is the streamlined review process, which is outlined in one of the appendices, one of the guidelines from the state. Which appendix was it? Sorry. Okay, so basically that special use permits or special permits are going to be generally be considered to be too much of a burden on the applicant. And the guidance is actually pretty explicit about that it is not a special use. And so it shouldn't require a special use permit. And right now, Washington does require that. And the guidance says that in general, it should be a as of right use. However, it said that site plan is not unreasonable either, but that if you do require site plan review, that they have these suggestions for a quote streamlined review, which has, it's just a little bit more lenient in the requirements. So there's the actual requirements, and then there's the definitions, particularly the definitions for farm or farm operation and agriculture. And our recommendation in terms of those definitions is to kind of follow what Amenia and Pleasant Valley do, which is they just kind of like refer to the state law. So for example, Pleasant Valley, the definition of a farm operation starts off as defined in the New York State Agricultural and Markets Law. And in that way, you're perpetually aligned with what the state says. Did I just say a lot of words that didn't make sense?
Yeah,
Or
yeah.
that makes sense.
I mean, it makes sense because we don't like when a farm operation wants to do any kind of expansion or anything like that, it falls under ag and markets law. So and the town doesn't really see anything come before it as far as like there's no site plan requirements or special use permit. But there is farm worker housing is treated as a special use permit for this town. So and because of that, you have that language in there that says, site plan is part of a special use permit too. And that could be another example where maybe site plan is certain things are waived, right? But if it's
But are we
it depends
able
on the
to have that?
application
'Cause
really.
I have to tell you, like, there's been some activity in our town in the past few years where people want to define something as a farm so they can build and do what they want. And I think that's I don't know. It'd be great to be able to have the planning board have some oversight of that, unless, is it what you're saying? We can't do that because it's against
Well,
our
an
local
important,
proceed, obviously, the state.
an important qualifier is that these rules from the state apply only to land that's within an agricultural district.
Right.
So you can have agriculture wherever it's allowed, but these protections only extend to farm operations within an agricultural district. So that's one
And usually,
check.
folks that are in an ag district and they're doing any kind of agriculture and they're getting the tax break associated with that, there's some oversight there. So, it's not like they're just doing things without any kind of oversight. If you want to get the tax exemption, you have to prove out that you're, working farm and stuff like that. So,
Yeah.
but I think the point here was like we had an application not long ago where there was an existing barn or something, right? Like on this agricultural property that they just wanted to retrofit to add a couple of apartments into it.
Right, I remember this.
For farm worker housing, and it fell under a special use permit requirement with the planning board. And then, the applicant was trying to push back and say, like we shouldn't really have to do all this because ag markets law allows us to do this, and the state says that it's being overly restrictive. And so it came up then, but still we went through the process and we only had them there for a couple meetings, but it could come up again in that situation. If there's even if it was a new construction building that wanted to provide the farm worker housing, I think that might fall under accessory structure and by default has to get looked at by the planning board, but we haven't seen that yet.
How
There might be.
narrowly defined is farm worker? How narrowly what's the
In there,
definition?
there's
of
the definition, I
farm
think.
worker?
Under the state or the
Yeah.
town's definitions?
Well, the town is probably similar. I mean, it's going to be probably broad. It's probably going to say something like an individual employed by a farm. And I think, Leslie, to your point, we just want to be careful that people don't take advantage.
For example, we have an ag exemption on 10 acres that is hayed by another farmer, and we fit the criteria for that. If I wanted to, could I build a barn and say it's for farm housing on that land, you know, I don't know. I don't know.
So it's right now, farm worker housing is a special use permit in the APO, in the town's
Mhm.
APO district. The agricultural protection overlay. I mean, if you want to keep that because of the importance of the agricultural protection overlay district, and it goes along with it, I don't think there's anything stopping that. It's just that we're going to get this question a lot from folks saying, well, state requirement isn't like this. Why are you making us do this?
Right. Well, that's actually happened. We had a case where we questioned a farm's operation, and they claimed that they were, you know, exempt from any oversight of having a farm stand. It kind of goes beyond a farm stand. It's a restaurant and some other things, but
Mhm.
they use the ag exemption. They use the state's ag laws as defense of what they were doing.
There
Yeah, but
isn't a
in lots of
definition in the
instances where
code.
we're
Yeah, no.
I'm sorry.
like our wetlands laws are more restrictive. And we do that because
Mhm.
it's important in our town for all kinds of reasons, environmentally, aesthetically, that's just our decision to be more restrictive. And this may be one because of the
The
sheer
APO.
number of ag
Yeah.
properties.
Well,
we may
sometimes
want.
the state law sets a floor, like with wetlands,
Yeah.
where the locality can, do more, and sometimes it sets a ceiling to say that this is the most that you can do.
Yeah.
Yeah.
I'm going to say 80% of our lands in our town are ag, in the ag district.
Hmm.
Looking at the map, it's at least
Yeah.
80%.
I mean, I don't know how on the one hand, we really do want to make it easier for working farms to have housing for their employees because there's so little housing, and so many of the alternative housing options have been gobbled up by kind of, to be rental properties or
Yep.
Airbnb type things. And so we don't want to make it harder for actual working farms who have seasonal workers and workers who need places to live to be able to do so. I also think we want to maintain some level of oversight, to Leslie's point. And I don't really know where you strike that balance, but
Well,
I don't-
since you have this APO overlay and all that goes along with it, it's really your call. But I think, and it's probably your justification is that we have this APO overlay, which is specific overlay zone in the town that has a lot of requirements. One of them being, if you want to add farm worker housing, we need to see a special use permit.
The APO includes the agricultural district, right?
I think it's
Hmm.
synonymous with
Yeah.
Ag
It's-
21.
Yeah.
There's
sure.
I forget where it is. I can find it, but there's two ways that something can be in the APO. One is being in the agricultural district, and the other is something about residentially zoned in 10 acres. So, talk about something else while I look this up. Oh, I'll get it in 1 second.
Okay. Should this be tabled for further discussion? What is the?
Yeah, I mean, it's just right
I
now
don't know if
there's
another way that we can, what Emily was, mentioning, is there an answer there where we can have some, because I think that the other thing is the question of the cost, right? Of them having to go before the planning board for these things. If it is something that's legitimately housing for which I think is probably most. I just had one situation where it was really being applied pretty broadly.
I don't see a definition in your zoning code for what a farm worker is,
yeah.
but maybe it's just because it's pretty obvious.
Well, would that be something that we'd have to, if we had that be more, if we just had it defined? I don't know. Is that too?
I don't know. I mean, maybe we see what other jurisdictions do if we can think of anyone who does anything. I mean, I don't know.
The APO district boundary generally covers lands that is residentially zoned and is either at least 10 acres and 50% agricultural soils or within a state certified agricultural district. So residentially zoned and either 10 acres and 50% agricultural soils.
Yep.
For the ag district.
So it's more than just the ag district, which falls under the ag markets law too.
Right.
So, I mean, it's restrictive, but if you want to keep it that way because you feel strongly about making sure that, you get a look at what's really happening, then I don't think you really need to change it. But, and you can, explain that to applicants is that, we have this APO, and, we're trying to control, density and things like that. And this is one way that we can have a look.
I mean, maybe this is one also Susan might want to weigh in on.
But would
'Cause I
you
know-
need to have the special use permit? Would that be necessary? Or could they look at it just with the site plan? Like, would the streamlined site plan be sufficient? Because then you don't risk bumping up against the state law, especially, I mean, at least if something's in the agricultural district. If it's in the APO, and it qualifies under the 10 acres and 50% agricultural soils, then, the town has a lot more flexibility in what they can require. But if it's within the agricultural district, would site plan be enough so the town can see what's going on?
Probably.
Probably because, yeah, I mean, special use permit doesn't always require a site plan. As the code states, there's flexibility there, but a site plan review is a site plan review, and it would be, but again, things can be waived based on the circumstances, but it prescribes the process pretty well.
Yeah, the special use thing makes me nervous because the guidelines like specifically provide agricultural uses in an agricultural district are not special uses. Like it says that clearly. So outside of the agricultural district, like whatever, but within it, I think it would be tough.
Okay. What do you think, Emily? Margaret?
I don't want to. I mean, I don't think I can make a decision, and I didn't get to look as closely as I'd like to have at the
Right.
memo before today. So maybe I can just take a look and
We should also get Megan and or Kyle to weigh in on this, no?
Yeah, I think that's the missing piece here. is
Yeah.
that. And what I'm going to try to get this updated and see if I can really get Vanderwater to, get back to us on some of these things that are more like the 25% and this and the cluster. But here it says you need a procedure for farm housing applications. I mean, it's possible that the actually application and not the code could be extensive enough that we feel covered, I don't know. I guess we have to apply the law, obviously, equally, right? We can't just, it's like in my mind, I'm thinking, oh, if Wallbridge was applying for something, it'd be different than someone who doesn't really have a act that is having something hayed or corn, but is not like having an active, they are the farmer versus because that's many people have their ag exemptions based on farmers farming their land versus being the actual farmer. So I don't know.
Well, I think, yeah, the legal, I guess a legal opinion on would be useful. And then we can maybe probably figure out a way to find a balance. I probably need more blood sugar.
Yeah, no, me too.
the
I'm
analysis.
very overpowered today. Okay, so why don't I do that? And there's a couple, the rest of these things here are pretty much things that are typos and things that Megan is working on. And so I don't know though, Emily, where the wetlands law, the CAC, I think Pam spoke with you and we kind of, I think we landed the plane on that. But I don't know if
I
there's
don't-
thoughts.
I don't know if there was anything. I don't know what was left on the wetlands law. I think Susan may have had the last discussion with Pam because I was out of pocket for a little while. And Pam and Susan and I both spoke to Pam, and I don't know what we were waiting for, but I think we addressed all questions.
Okay.
I think we're going to be discussing that tonight at our meeting,
Okay, so that's where we are then.
where the follow-up is. Yeah.
Great.
Okay. All right. So I'm going to update this and then we've got till the 21st. So I'll update that and then see which things I think are things that we need to have the planning board or Susan give us more feedback on. And then those first few that Tate, I don't think has gotten a chance to do. I'm going to see if I can get Frank to work on with Susan on some of those things, those checklist things.
Yeah, we had some stuff about telecommunication and logging too, but we could talk about that next time.
Okay.
It's fine.
All right, sounds good. Sorry, guys. I feel like, I'm glad we checked in just to kind of realize it, sort of what things are still very sticky. But I, haven't had a chance to, really respond to all the great stuff that Aaron and Alicia had submitted to us. So need to do that as well.
I just want to kind of like roll back something that so with the farm worker housing and special use permits, I want to throw some support behind what Aaron was saying, that the town could say that we do have this interest in protecting our low density rural character. Because even though the guidelines do say that agricultural uses are not special uses, it does qualify it later by saying, it says, absent any showing of an overriding local concern, generally an exemption from special use permit requirements should be provided to farm operations in agricultural districts. So that would mean that if there is an overriding local concern, that you could push it back, to requiring a special.
And that's probably why this came about in the code as it's written now, is because there was that concern about it getting out of control in some way.
Yeah, I think so because that's just my, that's my gut on that because of just to Margaret's point that there's just so much of our town that is in the ag district that the intent there was to kind of try to manage it a bit. Okay, everybody, I'm so sorry we're 15 minutes over, and I appreciate everyone joining, and I will work through that to-do chart, get some things to Vanderwater to ask them for deliverables in advance of the 21st, and give some items to Susan and to Frank Riddle to see if they can help work through some of those things in advance of that.
Okay.
Okay. Thank you all.
Sure thing. Good to see everybody.
Good to
Thank
see
you.
Likewise.
We'll be in touch.
Thank
Thank you.
Bye-bye.
Bye, everybody.